Ladies and gentlemen, please welcome the Roseville Wrecking Ball. The Roseville Wrecking Ball.
Joshua Shrum. He is a very talented steward, very knowledgeable.
The Roseville Wrecking Ball. This is one of those podcasts where I listen to every episode. I love what he's putting out there.
The Roseville Wrecking Ball. Josh Shrum.
Parcels of knowledge. Does a fantastic job with that podcast.
The Roseville Wrecking Ball. He is an Article 8 scholar, and thank God. We need Article 8 scholars right now.
Tune into the Parcels of Knowledge podcast while you're on the route. That's the mailman's playbook, brother.
Good morning and welcome back to Parcels of Knowledge, the podcast dedicated to delivering knowledge to the city letter carrier with your host, the Roseville Wrecking Ball. Today, on this wonderful Monday, we are on grievance number 370 in the beautiful city of Roseville, Michigan. I recently did a podcast on Richie Ray where 9 different podcasters came together and we had a pretty good discussion. So I heard that they're releasing that closer to the date of the convention. I believe August 1st. So shout out for that project. It'll be on Richie Ray's podcast, The Hot House. In addition to that, I just recently had another candidate on last Saturday. I plan on having Elliot Simmons, Region 7 NBA candidate, on this upcoming Saturday. On the 1st of August, same day as Richie Ray's podcast releases. And I think he's on it too. But I'm going to have him on. If you have any questions for Elliot Simmons, please send them to rosevillewreckingball@yahoo.com. That is rosevillewreckingball@yahoo.com. I'll take any and every question, and I'm going to go ahead and ask him it when we get there. Now, if there's any other candidates that want to come on the podcast, make sure you let me know. We're going to have anybody and anybody on that's running for national office because I believe in a fair and transparent election, and you can't have that without first understanding exactly who are the options. Now, moving on, I just would like to take today to talk about something that's been bothering me in terms of moving forward with the grievance procedure. It's a move that management had made that I think is a lot more significant than everybody is understanding. Recently, there's been a memo that's essentially problematic on every single page. It's a 5-page memo, I do believe. And it's just one big violation. And it's heading toward allowing every office to violate. Or it's essentially instructing them to. But we'll talk about it. This was released on July 6, 2026. And I'm going to read it and comment on it as it goes on. Subject, instructions and responsibilities for grievance settlements. And this is to all area directors, managers, labor relations, all district managers, all executives, managers, and supervisors. This memorandum sets forth instructions, responsibilities, and procedures for settling grievances. It does not alter the provisions of national collective bargaining agreements, which empower management representatives at each step of the grievance process to resolve issues and encourage resolution at the lowest possible level. That paragraph right there is trying to say, look, this is a violation, but we're going to tell you right now it's not. Because they're trying to say, hey, this doesn't alter Article 15 or alter national collective bargaining agreements. That right there should tell you all you need to know. It does. They're trying to bastardize your belief that it does in terms of like trying to file this as a national grievance, which it should be. This should be subject to a national level grievance because I can already see its ripple effects at my local level. General responsibilities. With the authority to settle grievances comes the fiduciary duty to conduct thorough investigation into the facts, protect the financial interests of the Postal Service. How many times have you ever heard that one? Ensure remedies, including monetary and non-monetary components, are appropriate and evidence-based and in compliance with national agreements. Postal Service rules and regulations and the law, including but not limited to the IRS, tax laws, and regulations. Understand what all the effects and implications of the settlement will be. Delegated authority. This paragraph right here in itself is a violation of Article 15, but you be the judge. In settling grievances, management representatives exercise only the authority delegated to them by senior management and ultimately the Postmaster General. This authority must be exercised in compliance with existing policies, regulations, laws, management directives, and contractual obligations. All previous delegations of settlement authority relating to the grievances are superseded by this memorandum. A management representative who fails to comply with the consultation requirements or other limitations or directions of this memorandum has exceeded the representative's delegated authority. Any settlement agreement entered into without actual authority is not binding onto the Postal Service and will not be complied with unless such agreement is subsequently ratified and approved by the Vice President, Labor Relations, or the Chief Human Resources Officer. First of all, we have settling grievance at the lowest level. This right here is making it sound like you can't settle grievances that your boss would not agree to. That's a bullshit and a violation. Additionally, it talks about any settlement agreement entered into without authority is not binding. Bullshit. Every settlement is final and binding. All right, next page. Higher level consultation. So this section deals with consulting higher level authority before you sign a settlement agreement. Our process is bogged down enough. And let me just explain to you what this really is. This is a code word for everything you need to consult with is code word for do not settle. They can't say don't settle these things. But in reality, they need to contact their boss before they settle them. You know their boss is too busy. Their boss is not going to want to talk about this shit. Josh over in Roseville is filing 370 grievances by the end of July. Do you think my postmaster's boss is going to want to talk about 370 settlements? No, they're not. Not whatsoever. What they're going to do instead is they're going to try to talk to their boss. Their boss is going to tell them once or twice, like, look, I don't want to talk about that shit. You should know what to do. You're smarter than that. And then they're just going to send everything up that's within this consultation mess. So let me read it. During grievance settlement discussions, consultation with higher level authorities authorized by the national agreement and contract interpretation manuals, and it may be necessary, for example, to identify similar pending grievances, learn the resolution of prior grievances, or assess broader impacts beyond the representative's scope of responsibility. These examples are not an exhaustive list of all the situations where higher level consultation is appropriate. Management representatives must exercise care and good judgment to identify all grievances for which higher level consultation is warranted. First topic, payout thresholds. In accordance with the exercise of delegated authority and the fiduciary duty of management representatives in the grievance settlement process, management representatives and labor relations personnel must consult with higher level authority before signing settlements when the total cost of a settlement exceeds the dollar amount designated for the representative's position as set forth below. It goes through a number of dollar amounts. The only thing that's really of importance here to note is that postmasters EAS 21 and higher, they are at $1,250. non-bargaining employees EAS 17 to 20, and all postmasters 18 to 20, $500. Settlements that exceed $1 million require consultation with the Vice President, Labor Relations, who will further consult with Chief Human Resources Officer. To determine the total cost of potential settlement, the monetary value of all tangible components of the settlement must be considered. This includes, but is not limited to, back pay, interest on back pay, reimbursements, the dollar value of leave, restoration or administrative leave, and training costs. Aggregation of related and like grievances. To determine when higher level consultation is required, the cost of settling like and similar related grievances must be aggregated. Labor relations consultation. Financial remedies that exceed make-whole relief. Financial remedies should generally be limited to a compensatory make-whole remedy. A make-whole remedy is defined for the purposes of this memo as a narrowly tailored remedy that meets the goal of returning an aggrieved party back to the position that he or she would have been but for the violation of the contract. For example, back pay, payment for wages lost, benefits lost, or expenses incurred. An appropriate make-whole remedy does not put the aggrieved party in a better position than he or she would have been but for the violation of the contract. An example of an appropriate make-whole remedy could be a reasonable lump sum estimate of actual wages lost. The payment of any remedy that exceeds make-whole relief should be avoided as only appropriate in extremely limited circumstances. Examples of the types of remedies and damages that must be avoided include escalating or compounding payments or penalties, any payment for inconvenience or pain and suffering, any remedies or payments labeled or described as fees, penalty, incentives, or motivation, any reoccurring payments such as damages that are to be paid on a per day or per month basis. So far they've said you got to consult if you go over this dollar amount. And now they're saying you got to consult if you go over this make-whole remedy. If you do anything escalating, you got to consult. What that really means is those two types of grievances are not going to be resolved at the lower levels. This is a violation because Article 15.3a, if I'm not mistaken, specifically states that management must make effort, and so does the union, to resolve these things at the lowest level possible. All management representatives and labor relations personnel must consult with the district manager, labor relations, before signing any settlement that agrees to payment of damages that exceed make-whole relief. Other mandatory higher level consultation requirements. All right. So these are just kind of random, I guess. All management representatives and labor relation personnel involved in grievance processing should avoid any agreement to the following types of settlement provisions and must consult with the district manager, labor relations, before signing a settlement that contains the following type of provisions. Future or repeat violations. Agreements to make payments for future or repeat contract violations. Each violation must be evaluated individually. Okay, so that's kind of like an escalator remedy anyway. All right. Or essentially it sets a precedent for the future. Payments made directly to the unions. Agreements to pay the union directly for any reason, including but not limited to its inconvenience in having to file a grievance. The national agreements provide reasonable on-the-clock grievance processing time and do not provide for inconvenience payments. Payments sent to the union for employee distribution. Agreements that a payment will be sent to a union for distribution to employees. Payment should be made directly to the affected employees via standard procedures. Cease and desist language. Agreements to cease and desist language. This language should be avoided as it may trigger claims of repeat violations. By the way, the reason I say this so many times, and I'm going to say this again, reason why cease and desist is a pretty big deal is because in the legal world, it's known as injunctive relief. In the contract world, our contract to be precise, it would be an example of an agreement to dispose of same or similar future issues, which means that if it's signed at Formal A, you can make that argument and that it would then set precedent. All we're setting for precedent is that they will stop. That's not a big deal. The problem is they're worried that we're going to escalate the remedy after asking them to stop for a number of times. What we're doing is reasonable. I recently had Kyle on. He's running for MBA for my region. I normally don't comment on the candidates, and I'm not saying anything about him, but he recently did talk about how we as a union, as a steward, as a carriers are taking advantage of escalating remedies or weaponizing them, as the service would put, and Kyle. I 100% disagree with this dangerous thought process because there is no other way to get management to stop unless we make them pay. So this cease and desist, this injunctive relief is important. So let me tell you this. If your manager is telling you no to cease and desist, tell them, how about this? We're going to put down as an agreement to dispose of same or similar future issues. Management will not violate. Blah, blah, blah. If you agree to those terms, it would be actually more powerful than a cease and desist. Because cease and desist, we argue that it is an agreement to dispose of same or similar future issues. Therefore, it sets precedent. If you cut out that middle terminology and you go straight to that particular phrase, what you're doing is you're actually just setting something that cannot be denied to be precedent. And that has value. In my opinion, that's more valuable. So if they're going to go over this issue, try and offer your counterpart that as an option. And then, of course, the next item is precedent language. Agreements to language saying that a settlement may be cited as precedent must be avoided. So that's how you get around that one as well. Because technically, it doesn't say the word precedent. If you look at Article 15, it says there's 2 ways to set a precedent at Formal A. Specifically say so, which they're referring to here, or make an agreement to dispose of same or similar future issues. Second option is, again, should be able to get management over the hump here and tell their bosses, well, he didn't say precedent. He didn't say cease and desist. They're going to be looking for those 2. They're not going to be looking for the one I just mentioned. The alternative to that, which is actually more powerful, just agreed that this is an agreement to dispose of same or similar future issues. Okay, moving on. We're almost done here, actually. I might have been mistaken. It looks like it's only 4 pages. Let me see. Yep, it's 5 pages if you include the cover page. Anyway, additional requirements for EAS 17 supervisors. So most of our informal A guys. EAS 17 supervisors and acting supervisors must consult with higher level authority in the following cases. Class action grievances. Before entering into a settlement of any class action grievance to assess impact on class members, non-members, procedures, and finances. First of all, I don't even know why they're concerned about class action. The designation of who the grievant is really doesn't matter because when we, unless we're talking about a financial remedy. But in terms of like language, class action has no impact. It's still going to apply if it says Josh is the grievant. It'll apply the same way as if it was class action. We're going to ask for injunctive relief regardless. And if it happens again, we're going to say, look, you agreed to stop doing it before. Why are you not stopping? I don't understand this weird class action thing. Policy or staffing changes. Before entering into any settlement that would result in change in policy or staffing, for example, a change in employee start times, work hours, routes, or duty assignments, and any change in managerial or supervisory staffing at any facility. Higher level consultation is required because these agreements often have an impact beyond the supervisor's defined area of responsibility. Once again, that's an Article 15 violation. It says right in the goddamn contract that both parties agreed to that every level has independent authority to settle. It does not restrict the agreement. The one caveat to that, for informal A specifically, is that it can't set a precedent for anything outside the bounds of that particular grievance. So it can be precedent setting for that instant case, but it cannot set a precedent for any future violations for informal A. Either way, this is still a really bullshit thing that they sent to everybody. Additionally, EIS 17 supervisors and acting supervisors must provide their immediate manager with a copy of every settlement they sign within 5 calendar days of the date of the settlement is signed by the supervisor. This must be a physical copy in addition to an entry in GATS. That's unusual because typically GATS, you don't get an entry unless it was formal A. Are they saying that they're going to enter informal and formal? I'm not sure. That's not a violation, but that's unusual. Compliance and review. This memorandum must be disseminated to all relevant offices. The installation head of every facility must ensure that all management representatives comply with this memorandum. It does not apply to the Office of Inspector General. Should you have any questions regarding the appropriateness of a grievance settlement or its potential to establish a precedent, please consult with Labor Relations. So, listen. This is a guise. The service knows how to pull one over, and I think that's thanks to Steiner. I think Steiner himself is the reason why they're doing all this sneaky business, because in the past, they've always been sneaky. But I think what sets this apart from what's happened before is the simple fact that I think they're better at it this time because they're trying the best that they can to avoid the appearance of a violation nationally. National, I think you need to be filing a grievance on this. I really hope you do. Brian Renfro, I know it's hard for you to do the right thing, but you need to be doing that because we have no choice with this matter. This is going to send ripples throughout the entire process, and I think that's the point. Like I said, there are many situations in this in which they tell you you need to consult. That is code word for do not settle. That's a big deal. If you listen to the Brian Renfro contract updates, you will know that Article 15 is on the table. Management is trying their best to get rid of Step B and replace it with something more favorable to them. And I think this is the catalyst in which they are going to bring to arbitration the results of this catalyst and say, look, Step B is not working. We need a better process. And I think this is going to be really dangerous, especially if the union doesn't understand what's going on or present that appropriately in an arbitration for the contract. I think we need to start fighting against this ASAP, activating alternate Step Bs, because what this is going to do is bog down Step B double as much as it was before. Everything's going to be sent up because many of us have established precedents that go against what this says here. You could have a grievance settlement that pays a certain remedy for the past 10 years. This settlement would require your management to consult still. With that being said, it's not getting settled again. It's getting sent up. And I think they're meaning it this time. I think they're going to bog down Step B. And then they're going to turn around with those results and say, look, Mr. Arbitrator, we asked the union to get rid of this step. We want a new step that actually benefits us. And look, this is the reason why it's not working. And they'll turn around and say, look, these are 100,000 cases stuck at Step B. We need to show management that we can get it through Step B and into arbitration. Well, maybe we can set it pending arbitration, but, obviously we might not have it arbitrated yet. That's going to be another big beast. We can do pre-arb sessions as long as we're not selling people down the river for $0. But I think that we need to get Boogie in. We need to fight this with as much as we could. And I don't think National is taking this as seriously as they need to. Every single carrier should be worried about this and the impact it's going to have on the grievance procedure. Hopefully, you learned something valuable today. And as always, have a good day.
If these guys are getting educated, we will be in big trouble.
Management's been weighing you down like a bag of wet catalogs, but you don't gotta take it. You strap on the elbow of education, dig it?
Ladies and gentlemen, please welcome the Roseville Wrecking Ball. The Roseville Wrecking Ball.
The Roseville Wrecking Ball is an Article 8 scholar, and thank God, we need Article 8 scholars right now. The grievance genius, the Roseville Wrecking Ball, doing amazing work.
Tune into the Purses of Knowledge podcast while you're on the route. That's the mailman's playbook, brother.